Rental agreements are legally binding contracts. But what happens when landlords don't hold up their end of the deal? In this video, we review the top 5 reasons tenants can successfully sue their landlord. Hey everyone, it's Alyssa here from Bay Property Management Group, the rental management experts, serving owners throughout Maryland, Virginia, Washington, D.C., and Pennsylvania. Before we get started, be sure to like, share, and subscribe for more content on creating passive income through real estate, plus tips for owners, investors, property managers, and tenants. So with that said, let's jump into today's video. A rental agreement is a legal contract between a tenant and a landlord or third-party owner representative. Unfortunately, contracts of this nature can result in all sorts of issues if not executed correctly. But today we are going to focus on 5 major disputes that often arise. These include, number 1, disputes over security deposit funds. Number 2, breaching a tenant's right to quiet enjoyment. Number 3, concerns over safety or livability. 4, landlords not following the legal eviction process. Or number 5, violating a tenant's consumer reporting rights. So let's get started breaking down each of these topics. Our first and most common reason that landlords and tenants end up in court is over the security deposit. That said, this could be due to the landlord not returning the deposit in time or withholding too much at the end of the lease. Any withholding should be clearly documented. In addition, landlords by law only have a set amount of time after move-out to return the deposit, which is typically about 30 to 45 days. If they fail to do so, tenants have the right to sue. In some jurisdictions, tenants may be entitled to up to 3 times the withheld amount plus additional court fees. However, avoiding this type of dispute is simple. Landlords must know the applicable laws in their area and complete a thorough move-in and move-out inspection. This includes taking detailed photos to document the property condition, and tenants should feel free to take part in the inspection process. It is also a great idea for them to take their own photos as added protection. Okay, next up we have breaching a tenant's right to quiet enjoyment. Quiet enjoyment can mean different things to different people. However, the law defines it as the right of a tenant to enjoy his or her rental property without interference. A lease's covenant of quiet enjoyment expressly obligates the landlord to ensure that tenants live undisturbed. Some of the common examples of actions that violate these rights include interruptions of utilities such as electricity or water, improper entry into the property without cause or notice, allowing others into the residence without due notice or consent, or violating a tenant's rights via gossip. In addition, landlords should never show up at a tenant's workplace to discuss landlord-tenant related issues. These harassing behaviors can lead to a tenant suing their landlord. Even worse, if the actions lead to the tenant feeling they need to vacate the property, a landlord could be left covering more financial damages than simply lost rent. The third most common reason that landlords and tenants find themselves in court is over livability or serious maintenance issues. Landlords have an obligation to provide safe and habitable housing. That said, not every landlord keeps up with the maintenance as they should, and a property can quickly fall into disrepair. While tenants may view small issues as a big inconvenience, livability deals with more serious concerns, such as a lack of heat, electricity, or water. That is, as long as it is not due to the tenant's failure to pay the utility company. Other examples include lack of proper sewage disposal, lead paint hazards, structural defects that pose a safety risk, or a severe infestation. Avoiding a lawsuit in this situation depends on the landlord's willingness to maintain open communication with the tenants and address maintenance concerns in a timely manner. The number 4 reason that tenants decide to sue is when landlords take eviction proceedings into their own hands. Evictions are a legal process that involves several steps and required notice periods. Therefore, any attempt to circumvent this process could be viewed as an illegal or self-help eviction. A few of the tactics a rogue landlord may use are changing the locks, removing tenant belongings, cutting off utilities, physical or verbal intimidation, or harassing behavior, which includes retaliation for tenants reporting the landlord's wrongdoing to any government agency. Any of these scenarios could prove to be dangerous for the landlord or the tenant, but they also allow tenants to sue for potential damages and court fees, which only further delays any lawful attempt at eviction. Last up on our list is when landlords take actions that violate the Federal Fair Credit Reporting Act. It is common to use consumer reports when screening applicants. However, these reports also play a role in the eviction process. Landlords must be acutely aware of all of the potential violations that can occur when utilizing data from consumer reporting agencies. Some of the actions that may violate a tenant's right includes not reporting tenants to the credit bureau, denying an application for unwarranted reasons that may later affect the tenant's ability to lease a home elsewhere, or unnecessarily requiring a cosigner. In addition, landlords can get into legal hot water by filing wrongful eviction actions, failing to send appropriate rejection letters that outline the reason for application denial, or requiring a higher deposit amount than is standard for other applicants. Besides what we have discussed already, there is one more problem that may land tenants and landlords in court, and that is when a tenant is injured on the property due to landlord negligence. For instance, let's say a landlord fails to fix the steps out front, leaving them uneven or unstable. If the tenant trips and falls, the landlord can be found liable, leading to potentially costly consequences. So the best answer is for tenants to report any safety issue as soon as they are noticed, and for landlords to take swift and appropriate action to mitigate the risk. With all of this in mind, let's take a moment to discuss whether or not a court battle is really the necessary action to take. Before taking such a drastic step, it is a good idea for parties to try to work together. As the tenant, the first step is to send a demand letter. This should clearly outline the concerns you have and request that the landlord take immediate or appropriate action. Just be sure to mention you are prepared to escalate the matter if necessary through the courts. If a demand letter does not produce the needed result, professional mediation is the next logical step. Some local jurisdictions offer advice or free resources that can help landlords and tenants resolve their issues without leading to a costly court case. Speaking of costs, this is another factor to consider before suing your landlord. If the case is successful, tenants may be able to recoup court costs or applicable legal fees. However, this is not guaranteed. Therefore, understanding the costs involved in pursuing the complaint through the courts will help weigh whether or not it is truly worth it. In addition, tenants must gather and review the evidence they have to back up any claims they intend to make. Keep in mind, any unproven accusations can quickly backfire, and in order to be successful in court, all parties must be able to prove their version of events. Still on the fence about whether or not your landlord-tenant issue needs to make its way to the courtroom? Well, we recommend talking to a qualified attorney before moving forward, and be sure to try working with the landlord first. Often, that will work out best for everyone involved. One of the best defenses against landlord-tenant disputes is to foster a healthy and professional relationship from the start. For more advice on a variety of issues important to the rental industry, subscribe to the Bay Property Management Group channel. Also, don't forget to hit the notification bell so you never miss out on exclusive content. If you like this video, please give it a thumbs up or leave a comment down below. Thanks for watching, and we will see you in the next video.